General exceptions to liability in tort include Volenti non-fit injuria, voluntary assumption of risk, inevitable accident, act of God, contributory negligence, necessity, statutory authority, and private defense, with landmark cases like Rylands v. Fletcher, establishing the principle of strict liability, Donoghue v. Stevenson, defining the neighbour principle in negligence, and Brown v. Kendall, illustrating the concept of inevitable accident. Key points about these exceptions. Volenti non-fit injuria. This Latin phrase means, to one who consents, no injury is done. Essentially, if a plaintiff willingly exposes themselves to a known risk, they cannot claim damages. Inevitable accident. If an accident occurs despite taking reasonable care, it may be considered an inevitable accident, and not actionable in tort. Act of God. Natural disasters beyond human control can be considered an act of God, and may relieve a defendant of liability. Contributory negligence. If the plaintiff's own actions partially contributed to their injury, it can reduce the defendant's liability. Necessity. In certain situations, causing harm may be justified if it was necessary to prevent a greater harm. Landmark case examples. 1. Rylands v. Fletcher. This case established the principle of strict liability, meaning a person can be liable for harm caused by dangerous substances even if they were not negligent, provided they brought the substance onto their land. 2. Donoghue v. Stevenson. This case defined the neighbour principle in negligence, which states that a person owes a duty of care to anyone who could reasonably be foreseen to be injured by their actions. And 3. Brown v. Kendall. This case exemplifies the inevitable accident defense, where a person accidentally injured another while trying to separate fighting dogs.